Facts giving rise to the causes of action: legal malpractice and attorney negligence. That on or about February 1st, 2011, the attorneys Rourke and Theodore commenced and presently continue an attorney-client relationship with an entity known as Grandview Palace Condominium of New York, a 396-unit condominium complex located in the hamlet of Loch Sheldrake, the town of Fallsburg, Sullivan County, New York. The 396-unit complex burned down and 2,000 unit owners lost everything, counterclaimant Peter Perino being one of them. At all times, attorney Rourke and Theodore held themselves out as confident in the area of laws, dealing with legal matters for which Grandview retained the services of attorneys. Counterclaimant Peter Perino and we the people of Grandview, and attorney Rourke and Theodore acted under an attorney-client relationship in which attorney undertook to represent Grandview. Counterclaimant Peter Perino owned and lived in a unit at Grandview Palace Condominium and therefore a client of the attorneys. Attorney Rourke and Theodore were required to exercise the same legal skills as reasonable, competent attorney and use reasonable care in determining and implementing a strategy to follow to achieve Grandview's best legal goals, mainly being the payment of $74 million in insurance proceeds. As a fiduciary of Grandview, attorneys Rourke and Theodore are obligated to treat all information regarding Grandview as confidential and to zealously represent Grandview's best interests within the bounds of the law, including the disclosure of any conflict of interest that might impair attorney's ability to represent Grandview. In the course of handling legal matters for Grandview, attorneys Rourke and Theodore negligently failed to act with a degree of competence generally possessed by attorneys in the state of New York who handle matters similar to Rourke's and Theodore. Grandview paid attorneys Rourke and Theodore large sums of money for the sole purpose of representing Grandview in legal matters. Grandview affirms that attorneys Rourke and Theodore were negligent and committed legal malpractice and breach of fiduciary duties to Grandview. Attorneys have wrongfully advised, directed, enforced, and have violated many articles of the HOA bylaws, First Amendment rights, New York state laws, and New York Lawyers' Code of Professional Responsibilities in the following regards. By failing to correctly and properly explain to Grandview that buying units using Grandview Association funds and investing in the risky real estate market is against the bylaws and not a delegated action, according to the bylaws. Article 8, Section 2 states, consent of unit owners to purchase or lease by the Board of Managers. The Board of Managers shall not purchase any unit without the prior approval of 75% in numbers and in common interest of the unit owners. Attorneys Rourke and Theodore did in fact plan, organize, implemented, and executed the wrongful act of purchasing units at the Sullivan County tax foreclosure auction, and even rigged the bid to aggressively and wrongfully obtain these units, just so to profit and make money. Upon information and belief, attorneys Rourke and Theodore demanded payments of $50,000 in legal fees for overseeing this illegal act and wasting Grandview's money. Attorneys refused to show an itemized invoice explaining these wrongful charges. Grandview do hereby respectfully request the court rule in favor of Grandview and order the attorneys, Rourke and Taylor, to reimburse the $150,000 that was lost due to attorneys' bad advice and illegal actions, plus all costs, fees, and interest and penalty associated with this wrongful act. By failing to appear for a court date and charge Grandview $5,000 in legal fees to defend a small claims action, which, due to attorneys' Rourke failure to appear in court, was lost due to attorney Rourke's failure to appear. Grandview do hereby respectfully request the court rule in favor of Grandview and order attorneys Rourke to reimburse the $5,000 plus all costs, fees, and interest and penalties associated with this wrongful act. By wrongfully advising Grandview and not alerting Grandview that falsification and misrepresentation of the insurance application will render the entire policies null and void, thereby leaving Grandview without insurance coverage. By denying access to fire investigators and tampering with evidence, attorneys Rourke and Theodore are responsible for the denial of $74 million in insurance proceeds, and to tamper with evidence by in fact removing evidence from the crime scene before it could be properly investigated, hindering the investigation and evidence tampering or alleging the insurance company denial of claim lawsuit. By failing to preserve the confidence and secrets of the client and violating privilege when attorneys Rourke and Theodore publicly admitted that evidence was in fact removed from the crime scene, especially after knowing that a whistleblower working with the insurance companies was present in the audience. Attorneys Rourke and Theodore are working against the best interests of Grandview and do not want us to collect our settlement. Grandview do hereby respectfully request the court to rule in favor of Grandview and order attorneys Rourke and Theodore and the law firm of Rourke, Fine and Janusis and its successor, Rourke, Fine LLP, to pay the cost of Grandview's insurance policies totaling $74 million, plus all costs, fees, interest, and penalties associated with these wrongful acts, to be paid in an account, administered by the courts and Peter Perino to rebuild Grandview Palace. Yeah. By mishandling and commingling of client funds and failure to produce financial records. By allowing 2,000 people to continue to live in a debt trap of a building without proper certificate of occupancy, inspection, and fire protection, endangering their lives and welfare, and thereby did in fact burn down. By wrongfully advising HOA not to bring building up the code, and this very bad advice led to a fire that destroyed everything. By demanding an illegal maintenance fees of $90 per month when the property does not have a proper certificate of occupancy and nothing to maintain. By demanding maintenance fees without a budget and a proper explanation of the spending of funds against Article 6, Section 1 of the bylaws. By wrongfully threatening to put liens on unit owners in good standing without proper due process of law. By illegally voted HOA units to stay in power against the bylaws. By withholding and denying access to fire insurance policies to unit owners to settle their own private insurance claim, especially when it is most needed after the fire, and then charging Grandview to see those policies. By wrongfully preventing and blocking an attempt to legally remove the board of managers against Article 4, Section 3. by allowing and managing every aspect of HOA accounts, receivables, payables, all banking, telephone inquiries, bookkeeping, answering phone calls, etc. To find out their arrears, HOA members must go through attorneys. How ridiculous. By taking advantage and abusing the frail, sick octogenarians board of managers, by wrongfully withholding financial records and fail to produce such records upon many demands, by wrongfully advising HOA not to pay school taxes and property taxes and jeopardizing Grandview's property of being in default of taxes, by wrongfully denying, suppressing, and infringing upon Grandview's unit owners' voting rights and right to free speech, by failing to maintain the integrity and competency of the legal profession in dealing with Grandview, by failing to represent the client, Grandview, competently, by overzealously representing Grandview above, beyond, and outside the bounds of the law, by failing to avoid even the appearance of professional impropriety. The appearance of wrongdoing is worse than the act itself. By holding themselves out as attorney for Grandview, but does not represent the best interests of Grandview. By taking large sums of money without any accounting and proper invoicing therefore. By making a secret deal to sell HOA vehicles to attorney Theodore's father for about $9,000, and counterclaimant Peter Porino, by just showing up to the auction, increased the bid up to $22,000, thereby making $13,000 for the association. By intentionally committing dishonest act, and by not fulfilling legal or contractual obligation, misleading the 396 unit owners of Grandview Palace. By violating basic standards of honesty in dealing with Grandview, and by failing to provide Grandview with the minimum standard of care. Counterclaimant Peter Porino have demonstrated that attorney's lawsuit against him is an action against public participation and petitioning. This frivolous slap lawsuit was commenced and continued without a substantial basis in fact of law and could not be supported by a substantial argument for the extension, modification, or reversal of such laws. Attorney's lawsuit lacked the cause of action, for the document in question is an absolute privilege document, which makes counterclaimant Peter Porino immune from liable pro se. Defendant respectfully seek a judgment to recover costs and attorney fees in the sum of $28,000. In addition to negligence and malpractice committed by attorneys Rourke and Theodore, as mentioned in the above paragraphs, attorneys frequently and fraudulently and recklessly induce Grandview to pay them large sums of money by making representation regarding legal matters which were untrue and false. Grandview requested that all legal fees, especially unearned and wrongfully billed, in the sum of $150,000 to be returned to Grandview. As a direct and approximate result of attorneys Rourke and Theodore negligence and malpractice, fraudulent inducement, Grandview sustained actual damages of $74 million and damages as stated above. Counterclaimant Peter Porino and we, the people of Grandview Palace, respectfully request the court rule in favor of Grandview and against attorneys Rourke and Theodore in the amount of $74 million in compensatory damages and damages as stated above. together with prejudgment and post-judgment interest, and all costs incurred herein to be placed in account administered by the courts and Peter Perino to rebuild Grandview Palace back to its glory days.
Thank you.